Welcome back to Pace Law Firm, talking with Alex Verduras, lawyer at Pace Law Firm. Alex, you recently wrote a bulletin that's up on pacelawfirm.com right now entitled Pace Law Firm Senior Litigator, you, delivers fatal blow to Fisco's mediation backlog. What is Fisco's mediation backlog? Why did you have to do something about it?
All right. Well, if there's a dispute between an insured person and an insurance company regarding statutory acts and benefits, the Insurance Act requires that you first must mediate the matter at the Financial Services Commission of Ontario, otherwise known as Fisco. Unfortunately, though, there's a 1.5 year time delay from when you apply for mediation to when you actually get a mediation. And that's intolerable. People are going without treatment. Treatment facilities are going without getting paid. And it's causing a great disruption in the system. And currently there's approximately 40,000 cases that are backlogged. And so when this particular issue came before my desk and before me, I looked into the matter and discovered that in fact there is a regulation to the Insurance Act that states mediations automatically fail 60 days after you apply for the mediation. And so realizing that,
That doesn't square at all then with the 1.5 year backlog that's going on.
Not at all. Certainly,
Right.
that was my opinion, not at all. And so I applied for arbitration on a particular file that was in this backlog that had not been formally mediated. And Fisco originally gave me a hard time, but I convinced them to accept the application. But they were saying, well, you hadn't mediated yet. And I said, well, I have, because I automatically failed. In any event, they eventually allowed it to go forward, but then State Farm, the respondent, the insurance company that we were asking for more money from, took issue with it and said, no, in fact, we had not mediated. And we eventually went before an arbitrator on this particular issue as to whether or not my arbitration could go forward.
Okay.
And whether or not we had mediated because it automatically failed after 60 days, or it had not mediated because we still had not had a formal mediation. And arbitrator Rogers at the Financial Services Commission of Ontario ruled in my favor, my client's favor, and agreed that after 60 days of filing the papers with the Financial Services Commission of Ontario, the mediation automatically failed, and therefore I was entitled to proceed to arbitration, which is the next step. State Farm didn't like that, and they appealed, as is their right. And the appeal recently came out, the decision on appeal came out, and Directors Delegate Evans ruled. He upheld arbitrator Rogers' original decision, and he again ruled that mediations failed automatically after 60 days. Now, there are some exceptions to all of these rulings. The parties can agree to extend the time, and they can do some other things. But essentially, if you want to move your file forward, if you're interested in getting your client money quickly, if you want to avoid this 1.5 year backlog, you can, the current state of the law is that after 60 days of filing, it's automatically failed, and you are entitled and legally able to move forward, either to court or to arbitration.
Now, lost in all this, of course, is the average person. You know, there's all these big words and there's all this alphabet soup and everything, and you're fighting for the average person. Maybe talk them through, like, what's the difference between you go from mediation, then you go to arbitration, and then you go where? How does it all work?
Right. Well, okay, that's a great question. So again, the law states that if there is a dispute involving you and an insurance company in terms of statutory acts and benefits, you must first mediate at the Financial Services Commission of Ontario. But mediation is not binding. In other words, a mediator can't force anyone to do anything. Okay. All they do is they just try and, what we say is, mediate. They try and bring the parties together. They try and effect a settlement. It's a forum to discuss matters, to point out the strengths and weaknesses of each other's case.
Okay.
But if it doesn't settle there, then you have a right. There are 4 things you can do, but the more traditional things you can do is you can then apply again to the Financial Services Commission of Ontario to arbitrate, which is similar to a court, but not exactly the same. But you have an arbitrator instead of a judge. But it's the same type of hearing. You know, you have witnesses and you have evidence, and you have an arbitrator, and he or she eventually makes a ruling, and that ruling is binding.
Okay.
Now, but there is also a right to appeal to what's called the Director's Delegate if you don't agree with that decision and you think that there was a legal error in the arbitrator's decision. And after that, if you don't agree with that, you could then appeal for judicial review to what's called the Divisional Court of Ontario. And it keeps going, it gets complicated.
That's why we have law school.
Right, but other than moving in the arbitration line, if your mediation fails, instead of arbitrating, you could decide to start a lawsuit in court for the same issues, for the same accident benefits that are in dispute.
Now, does everyone, but the process is the same for everyone across the board. If someone gets in a car accident, is this what they're looking forward to? Is it's going to be, first they're going to be a mediation, then there's going to be an arbitration, and on and on. Is that the way it works?
Well, usually how it works with, I think, 75% of matters, maybe it's 65%, some of these statistics, people play with, but you always have to mediate first.
Okay.
And about 75% of the cases settle at mediation.
Oh, wow.
So mediation is very beneficial, it's very useful. The problem is not at any cost, not at waiting around for a year and a half without the money you deserve, without the treatment you deserve, without the funding you deserve. And that's why I looked into this, and that's why I pushed this issue.
Well, you were saying that the healthcare providers themselves, I mean, sometimes they're going to help a person out even though there's no money coming in, but then after they have to wait 18 months before they're going to get paid, they could go broke.
Right, and so what happens a lot of times is a healthcare provider, say a physiotherapist, a chiro, says, I think my client really needs, my patient really needs treatment, and I want to treat them. Well, but the insurance company is denying treatment because their doctors don't agree with what you're doing. Well, but I know my patient better, and I think they really need the treatment, so I'm going to give them the treatment. But maybe they can withstand not getting paid for 60 days, for 90 days. But with a year and a half backlog, with Fisco mediations, and then if it doesn't settle, another delay in getting an arbitration or in court, a lot of these facilities are having financial difficulties carrying these costs.
Right.
And this case, hopefully, opens that up, brings us back to a reality of a 60-day mediation, makes us all comply with the legislation, and I think it's better for the client, frankly it's better for the law firms, and it's better definitely for the treatment providers.
Excellent. Alex, thanks a lot for stopping by. I'm sure we'll talk again on some more issues. That's Alex. You can find him at pacelawfirm.com, Alex Voudouris, and we'll see you next time. Bye.